Hey YouTube family and GN subs, Humberto from GrayLaw TV. For those of you who are new to the channel, what I do, I give you good news. You want bad news, you got to go to the other channels. What we do is we take complicated subject matter, we break it down, we make it real simple. Today, I have something that's a bit complicated, but I'm going to break it down. For those of you who may have fallen out of status, you still can adjust in the United States and get your green card. There are 3 different ways you could do that. I'm gonna unpack it. I'm gonna go through, make it simple. Good stuff, folks. You might wanna tune in and check it out, all right? The first way you can adjust in the United States is under what's called 8 CFR 245A, okay? That's where you're lawful generally. You can change from your lawful non-immigrant status to the green card. It's called adjustment of status. If you're out of status, however, you're not really able to adjust, right? There is a case called Matter of Quilantan. This is a case that's very important to adjustment. Basically, it applies in marriage cases where the individual has no lawful entry in the United States and they can't adjust generally. Generally, for marriage cases, you have to have 1 lawful entry. Doesn't matter that you're out of status. You can then adjust to the green card, all right, in the context of marriage cases. Well, this case, Matter of Quilantan, is very, very important because what it says is that some entries are lawful and you can adjust even though you didn't enter with a visa. So what happened in this case is the individual came driving in a car through the border. Immigration waved him in, didn't ask him any questions. That is considered a lawful entry. So how do you utilize these cases in practical terms, right? So what happens with my cases, I've done tons of these Quilantan entries, and folks, they don't know that this is possible. And so in their case, it was really, really important. Instead of trying to get a waiver, leaving the US, getting stuck outside, trying to get your green card and come back in, we adjusted them in the US. First thing that's critical in these cases, right? You provide a written statement and the statement has to be detailed, right? The statement has to say, all right, I'll give you an example, right? This is one of my cases. Clients from the Philippines, right? So the statement was, I woke up on, January of, 2020, got on the plane, got a visa to Mexico, flew from the Philippines to Mexico City. In Mexico City, I stayed in a hotel for 2 or 3 days, did some sightseeing. On the 3rd day, got on a plane, flew from Mexico City to Tijuana. In Tijuana, some of my mother's friends came in a car. It was a white minivan, picked me up. We drove through the border. The immigration officers asked the driver and the passenger only, I was in the back, asked the passenger only, what's your citizenship? They said US citizenship, waved them through. That was a lawful entry, even though my client had no visa, wasn't asked one question. You would think that that's an illegal entry. No, it's a lawful entry. We filed the adjustment, client got the green card. At the time of the interview, very important, the officer will do a separate Q&A for Quilantan, right? They will ask you questions. When did you leave your home country? Where did you go? How long did you stay? What time of day was it? What kind of car was it? Was the immigration officer at the port of entry wearing a blue or green, uniform? So they'll ask you the questions, and my clients are prepared to answer all of the questions under Quilantan. So that's great. One way you can get a green card, right? All right, let's talk about the second way that you can get a green card adjust in the US, right? It's called 245I. This applies both to employment-based petitions as well as family adjustments. If you have a case that was filed by you or on your behalf when you were a derivative, that means you were under 21. So let's say your dad filed for you back in 2000, right? You can use that petition to pay a penalty of $1,000 and still get the green card here in the US. All right. Now, you may think, well, April 2001, that's a long time ago. That's 20 years ago. Trust me, I've had cases where grandparents, filed for parents where the kid was a derivative. The kid could have come in, but the kid aged out, right? CISPA rules weren't really around. Even under CISPA, some age out, but they can utilize that petition under 245I to pay the penalty and get the green card here in the US. So let's talk a little bit about that, right? So if you had a case that was filed by you or on your behalf before January of 1998, then you need not prove, as you would otherwise, that you were in the United States on December 21st, 2000. Normally, if you have a case that was filed by you or your behalf after January 1998, you need to prove that you were physically present in the US on the day, right? Not during the month or that year, December 21st, 2000, right? So you get some documentation that you were in the US beginning of December, end of December, all through that month, and you're good. You could satisfy that requirement, but that is an additional requirement. All right, what's the third way that you can adjust in the United States? So this applies to employment-based petitions. So if you have a labor cert that was approved I-140, now you want to adjust your status. You have to have maintained your status the entire time. When you file the adjustment, you have to be legal, okay? So you have to prove that you were lawful in the United States at the time of filing the adjustment. Well, under 245K, you have 6 months that you can be out of status and still file the adjustment in the United States. Usually it happens when individuals are engaged in, unlawful employment technically, and they didn't know that they were unlawful. You can file under 245K and still adjust in the United States. You have to be careful. The 180-day period is in the aggregate. So let's say you had unlawful employment for 160 days. You file under 245K, but you continue for another 30 days to engage in unlawful employment. It knocks you out, okay? You don't qualify, so you got to be careful. You have to wait. When you file the adjustment, in 6 months, you're going to get a work permit. When that work permit comes, yes, then you can start lawful employment and you're good. Now, here's one trick with the 245K as well. So let's say you have that 160-day unlawful, working unlawfully in the United States. You depart the US, you come back legally, okay? It starts the clock again. You get a new 180 days. So sometimes that happens with my clients. You got to make sure you're up on that stuff. Hey, YouTube family, thanks so much for watching GrayLaw TV. Click below, like and subscribe. Give me a thumbs up, guys. We're still getting close. We're almost there. 4 million views, 50,000 subs. I am so excited, guys. Help me out, and we'll see you next time.